I'm the living, breathing man on the land and soil. The beneficiaries making special appearance sui juris propria persona under fraud, menace, and duress before fiduciary basher.
Defendants just simply have not created a genuine issue of material fact.
No offense, lawyers lie all the time.
Those are the plain facts.
And you being the trustee in this case doesn't matter?
Well, I'm not a trustee, sir. I'm a judge.
You are, because I appointed you.
All right, guys. Today we've got one of the craziest sovereign citizens to ever hit a courtroom. This dude just straight up stopped paying for his RV, like not even pretending to be responsible. And now he's out here screaming fraud at the dealership he got it from. But let's be real. He's broke and trying to scam his way into a free RV. The entitlement is actually insane. Don't worry though, the judge isn't having any of it. By the end, the court absolutely obliterates this guy. So here's the real question. Does he actually believe the nonsense he's spewing, or is he just trying to finesse the system? Let's dive in and watch this sovereign citizen get completely destroyed in court.
Bill, I did, just so you're aware, I did read through your response and attachments. So if you have, I'd like to hear what argument you have in response to counsel.
Without prejudice, I, Jeffrey-Lawrence Calgill, with Teresa-Ann Calgill, the beneficiaries making special appearance sui juris propria persona under fraud, menace, and duress before fiduciary basher. This is a Sesticate trust action, which you are now a real party in interest to. I'm the living, breathing man on the land and soil. The dead entity, all caps, Jeffrey-Lawrence Calgill, was expatriated, and I, the living man, have an unrebutted UCC-1 lien and security agreement with the all-caps entity, and Gary Basher serves as the entity trustee in a fiduciary capacity. Virginia law further provides to authorize such filing, the debtor must do so in an authenticated record by authenticating or becoming bound as a debtor by a security agreement, or 3, by acquiring collateral. I have supplied that to you, that there's a UCC-1 claim. The plaintiff's agents are outlandish, stating Federal Reserve published documents are hearsay. Statutes and constitutions are admissible under 56B, as it states. The defendant may move with or without supporting affidavits for a summary judgment in such party's favor as to all or any part thereof. Since the plaintiffs have violated RCWs, UCCs, and U.S. codes, among other laws, these laws are fact and admissible per CR 56B. The plaintiff says the conditional acceptance is a nonsensical document, yet it is in Black's Law Dictionary under conditional acceptance. The definition is an engagement to pay the draft or accept the offer on the happening of a condition. A conditional acceptance is in effect a statement that the offeree is willing to enter into a bargain differing from some respects from the proposed or the original offer. The conditional acceptance is therefore in and of itself a counteroffer. We conditionally accepted the offer of the plaintiff, but the plaintiff ignored us, knowing that the conditional acceptance stated acquiescence would void the original contract. The postal tracking combined with the Esquire Scroggins letter is fact and evidence to the plaintiff receiving the bills of exchange that they did not return. The plaintiff's agent, Esquire Bertolino, admitted they received them as well. What qualifications does any of the plaintiff's agents have to declare what is and is not a bill of exchange? Since the plaintiff's agents, the Esquires, lied about the redacting and have submitted evident affidavits that they are not qualified to submit, how can their words be trusted?
How can anyone take this dude seriously? First off, he's staring at his little piece of paper like it's a final exam he didn't study for, just trying so hard to read it out loud without messing up. And second, my guy actually had to clarify that he's a living, breathing man. Like, was that ever in question? Did someone think he was a hologram or a legal chatbot? The audacity of a sovereign citizen calling anyone a liar, especially the prosecution, is insane when he's the one out here spouting complete fiction about the UCC and quoting imaginary Supreme Court cases that, shocker, don't even support him and were actually huge L's. You can't make this stuff up. It's like watching someone try to pay for groceries with Monopoly money and then getting mad when the cashier won't accept it. At this point, he's either fully delusional or just too deep into the nonsense to back out. Let me know what you guys think. Is this guy actually buying his own BS? Or is he just stuck in it now? Let's get back to the madness.
They are not bankers, nor is Mr. Howard. What is his qualifications to make such declarations? He looks at a piece of paper, the plaintiff's agents hand him, and he takes it as gold. I have people at work that know federal and state policies and procedures, but they're clueless as to what those policies and procedures are for. How can Mr. Howard be trusted acting as an entity's agent? No offense, lawyers lie all the time. Fact, Agent Howard produced a terrible photocopy that has a signature on it for the dealership that is not on our copy. Who signed the contract? Can the plaintiff's agents prove that an authorized representative for the dealership that is delegated by the plaintiff signed that contract? The plaintiff wants to rely solely on the contract, so let's talk about the contract. Who signed it for the dealership? Why hasn't the plaintiff gotten an affidavit from the dealership? Because they don't know who signed it. Washington rule does state that the photocopy can be used in the original's place unless there's genuine question of the original. And that alone poses a major question. Where is the original? Is a signature on the original more legible? Is there any other evidential factors on the original that can give us the answers to that truth? On the UCC, we did tender for payment bills of exchange, who the plaintiff's agents are not qualified to decide with their opinion what is and is not a bill of exchange. And as for where the bills of exchange are, ask the plaintiff. What did they do with them? They did not send them back. What did they do with them if not monetize them for gain? Esquire Bertolino states that the instructions on the 1099-A state tangible property is not included, yet the exact wording is no reporting is required, meaning you don't have to, but you can. It does not say no tangible property, so Esquire Bertolino lied. The plaintiff has violated many UCCs, U.S. codes, not just 12 U.S.C. 5511B2, C codes and definitions on everything that the plaintiff has violated, and I have proven the facts. Why didn't the plaintiff return the documents they say are not bills of exchange with an explanation or dishonor? Why wait and have Esquire type up some bunk letter and still not return those bills of exchange? When you're doing something and you find out that there's fraud or some shenanigans going on, you stop. That would explain why we made payments until we found out that there was fraud. And if you use it without prejudice, like I have, a 1099-A can be anything I want. I can write a bill of exchange on a blank piece of paper. It's what they do with it. They didn't send it back with dishonor. They didn't send it back at all. All they said is, well, now we're going to limit how you can and cannot pay. And so they violated the UCC. And with that,
Finally, this dude really went off, yapping nonstop for a solid 10 minutes. Don't worry though, I trimmed it down for you guys because honestly, some parts were just too dumb to be seen by human eyes. He gave this long, dramatic speech like he thought he was about to deliver the legal equivalent of a mic drop, only for the judge to shut it all down in 2 seconds flat. And let's not forget, this guy is literally in court trying to scam someone out of a trailer. A trailer. He's pulling every made-up sovereign citizen trick in the book to steal an RV from the plaintiff, like it's some kind of legal loophole. Spoiler alert, I don't consent is not a valid legal defense. At this point, I don't know how much further he thinks he can take this, but honestly, someone needs to check on him. This dude is not mentally okay. Let's get back into it and watch the judge bring him crashing back to reality.
Response?
Thank you, Your Honor. The retail installment contract expressly provides that the borrower the borrower agrees to pay the amount financed and the finance charge in U.S. funds according to the payment schedule below, as explained on section 1 on the back. That's at Exhibit 1, page 2. It's undisputed that the defendants did not do so, that they defaulted under the terms of the contract. They don't dispute that they received the trailer. They don't dispute that they received this loan. They don't dispute that they made payments under this contract. They knew how to make payments under this contract. And they they don't deny that they stopped making those monthly payments. There is no genuine issue of material fact that they entered into the contract, that they defaulted under the terms of the loan, and that they owe the amounts set forth in the Howard Declaration. It's, not appropriate for defendants to malign attorneys generally, or my colleague, Ms. Bertolino, in this court, with no evidence, no admissible evidence that would support any of the allegations that defendants have stated here today. There is no demonstration, no allegations, no demonstration of fraud by the credit union or by anyone. There is no, defendants just simply have not created a genuine issue of material fact regarding the credit union's claim for breach of contract or its entitlement to replevin in this case. And that is, those are the plain facts.
So I got one question I have, which is not necessarily germane to my decision. Does your client still have the bills of exchange that were submitted?
That I don't have an answer for you today.
Your Honor, I've asked for them back and they just blatantly ignore me.
All right. Well, when I look through this, I mean, there's a lot of interesting theories that are kind of flowing all through this. What it boils down to, from what I gather, and there seems to be undisputed, is you folks went in, you bought a trailer on time, agreeing to make payments of some amount, pay it off. At some point in time, there was an issue arose where you decided to do something different, and then no more payments were made. There were some submissions of bills of exchange as an attempt to make a payment, as well as a 1099 as an attempt to make a payment. I guess my answer to that is those probably would not be something you could walk into Safeway and buy a banana with, because it wouldn't be considered regular money for purposes of buying things in a retail situation.
Who could have guessed? You can't just scribble a bunch of made-up laws on a piece of paper, hand it to your loan provider, and magically erase your debt. If that actually worked, we'd all be living in beachfront mansions by now. I swear, the world has seriously gone off the rails in the past few years. And honestly, I'm a little worried for the next generation. One day, some poor kid is going to have to learn about sovereign citizens from their own parents. Imagine trying to explain that to a 5-year-old. Well, buddy, some people believe the law doesn't apply to them because they wrote their own laws. It's just trash. Pure delusion wrapped in confidence. And the audacity of these people is next level. They never take responsibility for anything. And it's not just sovereign citizens. Entitlement has become a full-blown epidemic. Nobody wants to be accountable for their own actions anymore. But this guy and his cousin wife here are truly something else. Let's get back to the chaos.
They may work in a UCC type thing or something like that. This is simply a consumer contract to buy a trailer and make payments on it. And when you're all done, you get the title. The credit union, it appears without any objection, has a security interest, which is indicated in the title as the legal owner. And I've not heard, I mean, there may be some other claims, but that you may have against them. I'm not making an assessment of that, because even if you did, it would not upset the contract to buy the trailer. So, I mean, you buy the trailer, you got to make the payments, you make the payments, they get the trailer back. So I am going to grant the motion for summary judgment. In doing so, I want to just give you some guidance, sir. What will ultimately happen is they get the trailer back and then they sell the trailer to somebody else. They apply the funds they get from that against the bill that's still owing. So the more money they get out of that trailer, the less money you end up having a judgment for. that make sense? So it's in your best interest not to do anything to the trailer. It's probably in your best interest to hook it up and drive it down to the credit union because that would save some costs.
Oh yeah, I don't have a truck to do that, so they can come get it.
Oh, okay. I'm just trying to point out it's in
And
your,
so my copy of the contract not having a signature from the dealership doesn't matter.
it really doesn't.
And you being the trustee in this case doesn't matter.
Well, I'm not a trustee, sir. I'm a judge.
You are, because I appointed you one
I
as the
did-
beneficiary, because I'm not to do that.
Okay, I'm not able to accept that as a Superior Court judge.
So what about them just putting out our social security numbers without our say so? Like they could have completely ruined our credit. Someone could have those numbers and be doing damage to us right now.
Well, if those were passed to the attorneys as part of the collection, then that would be something that would be allowed. If that was sent out beyond that, obviously that's a separate issue. And if in fact that were a claim that were proven, there may be something there. But again, that doesn't affect the contract. Those are all other claims that you may have. And I'm not saying you do or you don't, because I don't know enough about those, even based on all the information that you filed. And I read through all the stuff you filed because it's what I do when I do my job. So
So can we have those forms of payment back?
I
Can
would.
you order them to return those to us?
Well, I think it's appropriate if there's some value in those should be returned to
There's a lot of value in them if they still have them. And if they don't have them, then
Then what happens if they don't?
I honestly didn't even know sovereign citizens came in pairs. It's almost kind of cute in a really dumb buddy comedy kind of way. They finish each other's sentences and share a grand total of, for brain cells. But seriously, what do these two think their little homemade contract is worth? You can't just type something up on your laptop, throw in some fake legal jargon, and expect a courtroom to treat it like gospel. If that actually worked, I'd have already sent my I don't know taxes agreement straight to the IRS. These people act like the legal system is just a suggestion, not a functioning institution that literally holds society together. And look, being broke is one thing. I can respect honesty, but pretending the law doesn't apply to you just because you don't like it? That's where I draw the line. Imagine if everyone in the country did this. It'd be pure chaos. And while I almost never feel bad for banks, I gotta admit, nobody deserves to deal with sovereign citizens and their nonsense paperwork. Not the judge, not the lawyers, not even the poor clerk who's just trying to get through their shift. None of them signed up to sit through a 30-minute rant about imaginary loopholes. But what do you guys think about this disaster? I'm honestly losing brain cells watching this unfold. Should courts start charging these people for emotional distress? Or would that just spark another fake lawsuit? Drop your thoughts in the comments, and if you're enjoying the content, don't forget to like and subscribe. I post every single day, so stay tuned for more. Thanks for watching, and take care.